Okay, good afternoon, everyone.
Good afternoon.
I'm getting feedback on my own voice. Welcome to the Office of Tax Appeals. My name is Judge Stanley, and this hearing is for the appeal of East West Bank. The hearing is being live streamed and will be posted on OTA's, the Office of Tax Appeals YouTube channel. So please don't share any personal information that you don't want to be made available to the public. A stenographer, Miss Alonso, is present, and she's reporting the hearing verbatim. To ensure we have an accurate record, we ask that each person speaks one at a time, avoid speaking over one another, speak clearly, loudly, and slowly. And when needed, Miss Alonso or any panel member will interject to ensure proper transcription. After the hearing, Ms. Alonso will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. As a reminder, the Office of Tax Appeals is not a court, but is an independent appeals body, which is staffed by its own subject matter experts, and it is independent of CDTFA or any tax agency. While the Office of Tax Appeals is not a court, we must nevertheless follow certain guidelines to ensure that we establish a proper record. Okay. Are there any questions before we go on the record officially?
No.
Okay. And Ms. Alonso, are you ready to proceed? Thank you. Okay, we're going on the record in the appeal of East West Bank. Office of Tax Appeals case number 2401-15150. The date is July 16, 2025, and the time is 2:52 p.m. The hearing is being held electronically by the agreement of the parties. Once again, I am Judge Teresa Stanley. I will be the lead for purpose of conducting the hearing. My co-panelists, Judge Aldrich, Judge Ridenauer, and I are equal participants in deliberating and determining the outcome of this appeal. I'd like the parties to introduce themselves and identify who they represent, starting with you, Mr. Wang.
This is Roger Wang. Good afternoon again, representing appellant East West Bank.
And CDTFA?
Jennifer Berry, Attorney 3, representing the department.
Jared Noble, Attorney 4, representing the department.
And Jason Parker, Chief of Headquarters Operations Bureau with the department.
Thank you. As stated in the minutes and orders, the issue to be decided in this appeal is whether appellant is entitled to a refund of excess tax paid to an out-of-state vendor in connection with a purchase that was not subject to California sales or use tax. Mr. Wang, do you agree that that's the issue?
Yes.
And Ms. Berry?
Yes.
Okay, great. Appellant submitted exhibits 1 through 16. CDTFA did not object to the admissibility of those exhibits, and they are admitted into evidence at this time. CDTFA submitted exhibits A through D. Appellant did not object to the admissibility of those exhibits, and they are also admitted into evidence. Neither party intends to call any witnesses to testify today, so I won't need to swear anybody in. Mr. Wang, you requested 30 minutes for your presentation, so you can proceed when you're ready.
Yes, I am. Thank you, Judge Stanley. Good afternoon again. Today, before the panel, is a case about the California Department of Tax and Fee Administration's, or the CDTFA's, negligence and intense disregard of the law based on the evidence and the law that is relevant to the transaction under appeal. Again, details of the transaction are found in the invoice referenced at Exhibit 1. First off, without any exceptions, the law is very clear about refund of excess sales and use tax collected by the CDTFA. Subdivision B, lowercase b, of Revenue and Taxation Code, or RTC, Section 6901, declares that any overpayment of the use tax by a purchaser, i.e. appellant in this case, to a retailer, i.e. Enterprise Network Solutions, or ENS, who is required to collect the tax and whose gives the purchaser a receipt therefore, i.e. Exhibit 1, shall be credited or refunded by the state, i.e. the CDTFA, to the purchaser. This specific rule of use tax refund is further reinforced by the CDTFA in California Sales and Use Tax Regulation 1684. Subdivision H, lowercase h, of this regulation promulgates that no use tax overpayment shall be made to the retailer, even though the retailer has paid the excess tax collection to the CDTFA, because RTC Section 6901 requires that payment of use tax be credited and refunded only to the purchaser who made the overpayment. To distinguish sales tax collection from the use tax collected by non-California retailers like ENS, the CDTFA issues a use tax permit, commonly known as Certificate of Registration Use Tax, to these retailers, as required under Subdivision E, lowercase e, of Regulation 1684. Additional information about this use tax permit and related use tax collection required of non-California retailers is available in the CDTFA's position or discussion papers, referenced as Exhibits 5 and 6, notably pages 6 through 8 in Exhibit 5. That is the law. Now, as the panel browses through the evidence presented by appellant, it's undeniable that the excess tax amount on page 2 of Exhibit 1, collected by ENS and paid to the CDTFA, is a use tax overpayment based on the related corroborating evidence. First, in terms of the corroborating evidence, as displayed in Exhibit 2, ENS tax permit or account start with two notable alphabet letters, S and C. And pursuant to Exhibit 7 and 7.1, that are excerpts from the CDTFA's audit manual. These two letters, again, SC, are specifically designated and used only for certificates of registration use tax permit holders like ENS. Here, it should be noted that besides the use tax overpayment made on this ENS transaction under appeal, appellant also paid hundreds of identical use tax overpayments to other non-California retailers. Exactly identical in terms of both forms and fact pattern pertaining to all the invoices. The only difference between these overpayments and that collected from ENS is that the CDTFA has refunded all these identical use tax overpayments to appellant. To wrap up, as of today, as confirmed in Exhibits 14 to 16, the CDTFA still has not refunded the use tax collected from ENS, the use tax overpayment collected from ENS to appellant, even though the law clearly requires the CDTFA to do so. Thank you. Now, appellant welcomes any questions the panel may have. Oh, by the way, earlier mentioned the identical use tax of overpayment made to other non-California retailers. Several proofs of this paid use tax refund are found in exhibits 10 through 11.1. Thank you again.
Thank you, Mr. Wang. Judge Aldrich, do you have any questions for appellant?
Not at this time, thank you.
Judge Ridenhour, do you have any questions?
Also not at this time, thank you.
Okay, I may have one, but I'll hold it until after CDTFA's presentation, see if I still have the same question. Ms. Berry, you requested 20 minutes for your presentation, so you may proceed when you are ready.
This appeal centers around a claim for refund that appellant filed with the department on July 30th, 2014 for the period April 1, 2011 through December 31, 2011 in the amount of $10,822.88. A copy of appellant's claim for refund is available as Exhibit C. Appellant's claim for refund relates to a transaction with its vendor, Enterprise Network Solutions. The transaction is described on purchase invoice number INV 4070A. That invoice is dated August 1, 2011, and shows that appellant purchased, among other things, computer, hardware, software, and licenses from Enterprise Network Solutions. The invoice is available on pages 15 and 16 of Exhibit A. The invoice included the $10,822.88 charge for, quote, sales tax, which Enterprise Network Solutions subsequently remitted to the department. Despite Enterprise Network Solutions charging and appellant paying the charge for sales tax, it is undisputed that the transaction was not subject to California sales or use tax because Enterprise Network Solutions shipped the property in question from Arizona to appellant's branch location in Arizona for use in Arizona. Accordingly, on November 18th, 2013, Enterprise Network Solutions filed a claim for refund with the department seeking a refund of the $10,822.88 in excess tax reimbursement that it erroneously remitted to the department for the invoice at issue. Enterprise Network Solutions claim for refund is available on page 17 of Exhibit A. Enterprise Network Solutions also notified appellant of the error and pending claim for refund by email dated December 4th, 2013, and providing appellant a notice of pending refund of excess sales tax reimbursement on Form BOE 52-L2 dated December 5th, 2013. A copy of the email and form are available on pages 18 and 19 of Exhibit A. Along with the email and form, on December 4th, 2013, Enterprise Network Solutions issued a credit memorandum for the corresponding charge and a separate invoice in the amount of $9,957.04 for the corresponding amount of Arizona sales tax to appellant. The credit memo and invoice for the Arizona sales tax are available on pages 22 and 23 of Exhibit A. Thus, on December 4th, 2013, Enterprise Network Solutions refunded appellant the erroneously collected California sales tax reimbursement attributable to the original transaction and applied the refund amount as a credit towards Arizona's sales tax imposed on that transaction. Thereafter, the department issued a notice of refund dated May 16th, 2014, granting Enterprise Network Solutions claim for refund. This notice of refund is available on pages 20 and 21 of Exhibit A. As a general matter, Pursuant to Revenue and Taxation Code Sections 6051 and 6091, California imposes sales tax on a retailer for its retail sales in this state of tangible personal property measured by the retailer's gross receipts, unless the sale is specifically exempt or excluded from taxation by statute. Where sales tax does not apply, Revenue and Taxation Code Section 6021 imposes use tax on the storage, use, or other consumption in this state of tangible personal property purchased for use in this state unless the use is excluded or otherwise exempt. However, neither the sales tax nor the use tax is imposed on retail sales of tangible personal property occurring outside of California for storage, use, or consumption outside this state. Additionally, sales tax is legally imposed on the retailer, not the consumer. Civil Code Section 1656.1, Subdivision A, authorizes a retailer to collect sales tax reimbursement from its customers on the sales price of tangible personal property sold at retail. A retailer's collection of sales tax reimbursement does not shift the legal liability for the tax to the customer. It is merely reimbursement for the sales tax imposed on the retailer.
Okay, Ms. Berry.
Yes.
Can you slow down just a little bit?
Sure.
Thank you.
Do you need me to repeat anything? No? Okay. Pursuant to Civil Code Section 1656.1 and Regulation 1700, Subdivision A, Paragraph 2, Subparagraph capital B, when sales tax reimbursement is shown on the sales check or proof of sale, it is presumed that the parties agreed to the addition of sales tax reimbursement to the sales price of tangible personal property sold at retail to the purchaser. As explained in Appeal of Bodywise International LLC, the citation of which is 2022-OTA-340P, there is a statutory presumption that tax collected is a sales tax reimbursement where the following apply. First, tangible personal property was sold. Second, the sale was at retail. And third, the retailer charged an amount for sales tax reimbursement on the document of sale. With regard to the collection of excess tax reimbursement, Revenue and Taxation Code Section 6901.5, along with Regulation 1700, provide that when an amount represented by a person to a customer as constituting reimbursement for sales tax is computed upon an amount that is not taxable or is in excess of the taxable amount and is actually paid by the customer to the person, the amount so paid is excess tax reimbursement. Regulation 1700 further explains that excess tax reimbursement is charged when, among other situations, reimbursement is computed on a transaction that is not subject to tax. Bodywise International also makes clear that it is not necessary for a sale, purchase, or any other type of transfer for consideration to be subject to California's sales tax in order for the excess tax reimbursement provisions of Revenue and Taxation Code Section 6901.5 to apply. Once the retailer has remitted the tax reimbursement to the department to submit once the retailer has remitted the tax reimbursement to the department, the sole legal avenue available for determining the proper application of tax is for the retailer to submit a claim for refund under Revenue and Taxation Code Section 6901 and following. This is also set forth in the Business Tax Law Guide annotation number 460.0028. Pursuant to Revenue and Taxation Code Section 6901.5 and Regulation 1700, Subdivision B, Paragraph 2, whenever the department ascertains that a person has collected excess sales tax reimbursement, the person will be afforded an opportunity to refund the excess collections to the customers from whom they were collected. In the event of a failure or refusal of the person to make such refunds, the department will make a determination against that person for the amount of the excess tax reimbursement collected and not previously paid to the state, plus applicable interest and penalty. There is no provision in the law for an action on the part of a non-taxpayer, the purchaser, to dispute the application of tax. Revenue and Taxation Code Section 6901 provides in pertinent part that if the department determines that any amount of tax, penalty, or interest has been erroneously or illegally collected and the department determines that the amount was not required to be paid, the department is required to credit or refund that amount to the person from whom the money was collected or by whom it was paid. Under Revenue and Taxation Code Section 6901 Subdivision B, any overpayment of the use tax by a purchaser to a retailer who is required to collect the tax and who gives the purchaser a receipt, therefore, is to be credited or refunded by the state to the purchaser. A person who paid use tax has standing to file a claim for refund of any such use taxes that the person claims is overpaid. As set forth in Honeywell Incorporated versus State Board of Equalization and Code of Civil Procedure, Section 720.360, a third party claiming a refund, in this case appellant, bears the burden of establishing his or her entitlement to the refund. Turning to the facts of this case, we first note that the invoice for this transaction clearly and explicitly states that the tax charged and collected upon the tangible personal property sold thereunder was sales tax. This designation on the invoice triggers the statutory presumption set forth in Civil Code Section 1656.1 that the amount for sales tax reimbursement is sales tax reimbursement. As noted in Bodywise International, it is not necessary for the invoice to use the exact phrase California sales tax reimbursement in order for the statutory presumption to apply. The court in Loeffler v. Target Corporation similarly held that a charge labeled simply sales tax on an exempt food sale constituted excess sales tax reimbursement. In this case, the invoice uses the term, quote, sales tax 8.75%, and Enterprise Network Solutions subsequently remitted that corresponding amount to the department. Thus, the statutory presumption set forth in Civil Code Section 1656.1 applies here. Moreover, as set forth in Bodywise International, under the sales and use tax law, it is not necessary for a sale, purchase, or any other type of transfer for consideration to be subject to California's sales tax in order for the excess tax reimbursement provisions of Revenue and Taxation Code Section 6901.5 to apply. And the requirements of that section apply whether the underlying transaction is non-taxable, taxable, or exempt. In this case, as stated earlier, it is undisputed that appellant's purchase of the tangible personal property in this transaction was not subject to California sales or use tax, since the sale both occurred in Arizona and was for use by appellant in Arizona. Thus, Enterprise Network Solutions charge and collection of California sales tax reimbursement for this invoice from appellant upon a non-taxable transaction was, by its very nature, excess tax reimbursement under Revenue and Taxation Code Section 6901.5 and Regulation 1700. Moreover, the department followed applicable statutory law and procedures to review Enterprise Network Solutions' claim for refund and correctly refunded the amount to Enterprise Network Solutions. As discussed in Loeffler v. Target Corporation, under the procedures established by the sales and use tax law, the department can ascertain whether excess reimbursement was charged during an audit, during a deficiency determination proceeding, or in reviewing a taxpayer's claim for refund. However, Revenue and Taxation Code Section 6901.5 provides no procedure by which consumers, such as appellant, can require the department to ascertain whether excess tax reimbursement has in fact been charged. However, this is exactly the remedy that appellant is seeking. Appellant's suggestion that the transaction involved use tax rather than sales tax ignores the undisputed fact that this transaction was not subject to any tax, whether sales or use, in California. Additionally, appellant relies on Revenue and Taxation Code Section 6901, Subdivision B, to support its contention that the department must refund the amount Enterprise Network Solutions remitted to the department to appellant. Regulation 1684, Subdivision H, which governs the refund of excess collections of use tax by a retailer, requires the department to refund these collections to the purchaser when it ascertains that the retailer has either collected use tax from a customer in excess of the amount required, or has collected from a customer an amount which was not taxed but was represented by the retailer to the customer as being use tax. Neither of these circumstances are present here. As a threshold matter, for Revenue and Taxation Code Section 6901, Subdivision B, and Regulation 1684, Subdivision H to apply, the transaction must have been subject to use tax in the first place. As we have noted, Enterprise Network Solutions was not required to collect or remit any California tax, and certainly not use tax, on the transaction at issue here, because the transaction was not subject to California sales or use tax in the first place. Moreover, as discussed above, the invoice explicitly describes the charge as sales tax, not use tax. So there was no representation by Enterprise Network Solutions that it was collecting use tax from appellant. Thus, appellant's assertion that Revenue and Taxation Code Section 6901, Subdivision B governs this claim for refund is without merit. Appellant has not, therefore, established that it is entitled to the refund that it seeks. Finally, it should be emphasized that the heart of appellant's contention is that the tax was erroneously allocated to California by Enterprise Network Solution and later improperly reallocated to the state where the sale was subject to tax. Hence, appellant is essentially arguing that it should be unjustly enriched by granting it a refund for the tax collected on the initial transaction. And appellant is attempting to assert that California should reclassify the line charged for sales tax as use tax simply because appellant believes such reclassification benefits their appeal. Therefore, granting an additional refund to appellant here would result in appellant being twice refunded for the same charge without any legal basis to do so. As discussed earlier, Enterprise Network Solutions issued a credit memo and invoice for the applicable Arizona sales tax to appellant on December 4th, 2013. To the extent that appellant may believe that Enterprise Network Solutions has erroneously applied the credit amount to Arizona sales tax for the transaction, appellant's dispute is with Enterprise Network Solutions, not the department. Were appellant to receive a refund from the department now, appellant would receive a windfall, while the state of California would effectively offset the burden of Arizona sales tax on this transaction for appellant. There is no basis in law to support such a result. Thank you.
Thank you, Ms. Berry. Judge Aldridge, do you have any questions for the department?
Yeah, one quick question for the department. So according to the CCP 1656.1, the presumption's rebuttable. How would one go about rebutting that presumption?
I have some information on that. If we had a transaction that was indicative of use tax, such if the shipment invoice noticed that East West Bank was receiving property in California versus in Arizona, we may have an erroneous collection of use tax there. The problem we have with this case is that there was no tax subject at all. So that may be a situation where use tax was erroneously charged and collected. And again, we would look at the invoice to make sure that it had a designation for tax or use tax as something along those lines. Certainly not a sales tax designation on the invoice.
And one more question, and this might be better directed to Mr. Parker, but the 8.75 rate that appears on the invoice, is that consistent with any sales tax rate at that time in California?
Yes, I believe, we had 8.75 tax rates during that time.
Thank you. No further questions from me, Judge Stanley.
Judge Ridenhour, do you have any questions?
No questions, thank you.
Okay, and I just have one clarifying one for Mr. Wang. It sounds like the property was never brought into California. So it was never stored in California or delivered. I know it was delivered to California, but it was never to Arizona, I'm sorry. But it was never delivered, it was never in California, right?
Yes.
Okay. Mr. Noble?
I just want to know, like, if we had situations where it looked like the evidence indicated that there was a potential of a use tax liability versus sales tax liability, we would look at whether a refund was granted to the vendor or the taxpayer here. So the dispute we have is the fact that this was not subject to any California tax and it never entered California. Hence the problem. So.
Okay. Mr. Wang, you can have 5 minutes to make any final statement that you wish to.
Yes, in addition to that, Justice Stanley, since I'm going to have some more information, so can I use some of the remaining time of our presentation to address the issue presented by the CDTFA?
But
In addition to the 5 minutes, yeah.
Excuse me, but you want to address an issue that
No,
they
I just
raised?
in that rebuttal, within, I know that our time is allotted about 5 minutes. My
Okay.
question is that since we still have appellant still has some remaining time in his presentation, can appellant use some those additional time in addition to the 5 minutes allotted to it? That's my question.
Oh, I see.
Yeah.
I see. You didn't take all of your 30 minutes at the beginning.
Exactly.
So you want
Yes.
you want more than 5 minutes now.
Yeah, that's
Okay.
my question. Yeah, apologize for
Okay.
not being clear to that.
Okay. You can proceed.
Yes. First and foremost, in rebuttal to the presentation by the CDTFA, appellant would like to clarify something regarding the code section of in the Revenue and Taxation Code. The code section 6901. First of all, that is the first issue appellant want to address it. The 6901.5 code section only applies. Okay, let me step back. Both code section 6901 and 6901.5 address refund of excess sales and use tax collected by the CDTFA. Now, more fun. But the only difference is that 6901 would apply in this case only if the excess tax amount collected by ANS did not pay to the CDTFA. That is the only distinction whether which code section applies. First of all, if as a retailer on my invoice the sales tax amount, it's up to me whether I label that as a sales tax and some other, in this case ANS label as a sales tax, but some retailers labels as the sales / use tax on the invoice. And that tax amount is well known as a reimbursed tax is the tax reimbursement. Any when there's a tax amount collected by a retailer, that is a term is within the RTC, for California sales and use tax purposes, it's termed as a tax reimbursement. Now, excess tax reimbursement is the same as tax overpayment. In 6901.5, the term excess tax reimbursement kind of like overused by the CDTFA as a sales tax overpayment. No, it's not. It's only said excess tax reimbursement can be either excess sales tax reimbursement or excess use tax reimbursement. But once in this case, the excess tax amount in this case already paid to the CDTFA by ENS, then that code section 6901.5 no longer applies. And now it's in that's in that situation, 6901 is the only statute applies in this case. Yeah, that's true. I agree with the CDTFA is that 6901.5 of course allows a retailer to either return the over collected tax amount back to the customer or pay to the state. Now, because ENS already paid to the state, the CDTFA, 6901.5 no longer apply out of the picture. It's only 6901 applies. And then, when it comes to the 6901, the CDTFA already have the money in its hand. And it's have to figure out, is this a use tax errors or a sales tax errors? Oh, by the way, if it's highly noticeable that within the language of the code section 6901 is that the code statute put any in there. Any means that overpayment may result in inaccurate tax rate or like double taxation. And even though the case, in this case, a transaction should not have been subject to the tax on this transaction should have been collected and paid to the CDTFA because the property never set foot inside the state. So that if that kind like is if saying that the assertion that section 6901, code section 6901, especially subdivision B, does not apply to this this situation, is invalid. It's has no basis in the eye of the law. Go ahead, Mr. Noble, if you want to chime in. You're welcome to chime in.
Okay, is this the right timing, Mr. Noble?
I will wait for you to defer to me to answer. I just wanted to offer a response, but I'm not going to interject and interrupt anybody.
Okay.
No, go ahead. Yeah.
Okay, so you want to respond to a question that was just raised?
No, I just want to know that the end result of this is that appellant paid tax reimbursement to the vendor for a tax liability that was allocated to the wrong state. At the end of the day, the vendor remitted tax to California, took that credit and remitted it to Arizona. An appellant is looking for a technicality to result in unjust enrichment to get basically in a tax exempt purchase.
Okay, I think the panel understands that, Mr. Noble, so we'll return to Mr. Wang and let him conclude.
Yes, ma'am.
So yeah, so that's the first issue. The appellant would like to bring to the panel's attention the distinction between the application between the two code sections. That is very important. That's the only distinction is that. Okay, so again, section 6901.5 doesn't apply in this case because again, the fact is that ENS already paid this excess tax amount to the CDTFA. That period. Now the second issue is about the other identical use tax overpayment that appellant paid to other non-California retailers. It's the same pattern, because in those cases, the property, again, never on those invoices, the property was shipped outside California and for use outside California. And then because just like ENS, these are use tax collection permit. These vendors holding a use tax permit, and the nature of their tax by default is a use tax, regardless of overpayment. As long you know the tax paid to the CDTFA, that is a California sales and use tax, regardless whether that transaction in the beginning was subject to California sales and use tax or not. So that's another second issue that appellant would like to bring into the panel's attention. Yeah, so that's that.
Mr. Wang, your screen froze.
Now, the third issue one. Go ahead. Hello?
Your screen is frozen, but I can hear your voice. So
Okay, yeah. I'll be good connection. Apologize for that, Stanley. Now, I was saying that the tax, unfortunately, is an error. Should never been collected and paid to the CDTFA. But then, again, they pay to the CDTFA. Code section 6901 applies, and the language in the code section doesn't set any exception, any condition, including, in this case, because the tax subject to Arizona tax, therefore, it doesn't apply. Oh, by the way, whether and how the tax should be paid to Arizona, is irrelevant today, because before the panel today is a matter of California use tax overpaid to the CDTFA. So now the issue number 4 means that the CDTFA claimed that in this case, appellant would with double windfall. The appellant would like to share with the panel in a short minute that what happened in back 2013. Back then, appellant was ready to file a use tax refund claim with the CDTFA upon notification of this use tax overpayment by ENS. However, due to the same outcome, appellant agreed with the recovery of this use tax refund through ENS out of the convenience for the CDTFA, and more importantly, under the fully agreed guarantee arranged by the CDTFA that ENS would return the refund money to appellant after it received from the CDTFA. This fact is very clearly stipulated in Exhibit 14 and 14, in which the language in that form 50 BOE 52L, that too, they clearly say that, yes, earlier I said that, appellant said that the code section, this law does not set any condition that would relieve the CDTFA of this legal obligation with respect to this use tax refund claim. Use tax refund owed to appellant. But yet, the statute allows the CDTFA to recover the money, the refund money it had issued to the ENS. Again, look at the in Exhibit 4 and 14, where it very clearly say that ENS will pay the refund to appellant after once it received from the CDTFA. Otherwise, the ENS will be legally liable for any penny of the refund that not returned to appellant. As a matter of fact, that's the case. Now, the CDTFA can go after the ENS because the law allows the CDTFA to do so. In sum, to wrap up again, as of today, based on the evidence, based on the law, the law in this case, appellants has not received any penny of this use tax refund collected by the CDTFA.
Mr. Wang, I have a question with regards to that. So
Yeah,
did your client reject the credit that EMS gave them with regards to the money that is equated to the tax paid? Did they say, no, we don't want this credit, we want cash instead?
Yes, as is clearly stipulated in the in Exhibit 4 and 14, where the appellant checked the box, refund and money to it. Yeah.
I understand they checked the box electing that selection, but I'm asking you, when your client then got a credit for a subsequent purchase, did your client reject the credit?
Yes, it did. I mean, it's in real terms, appellant didn't have any choice. But I mean, now back then, if you notice, just right now, appellant and ENS ceased to do business in 2012, and ENS were audited by the CDTFA in 2013. Because of that fact, appellant already in process of working internally to receive cash refund from the CDTFA and turn around to find some way, like for instance, in Arizona, just like in South California, if in the case, if you're a retailer, you didn't properly collect the tax on the invoice, and then later on found out after the fact that amount of tax, original, even there's a sales tax, is no longer the sales tax situation. Now it become either the sales tax or the use tax imposed on appellant in this case by Arizona. So therefore, appellant internally was in the process of one hand recover the money overpaid to erroneously paid to the California, and then internally turn around and pay in the terms of use tax to Arizona. Didn't take place. That didn't, again, appellant didn't have a choice, because as you saw in Exhibit 16, ENS took the liberty, even though it signed the document, Exhibit 4 and 14, promising, guarantee to the CDTFA that it will return the refund money to appellant, and it did not. And not only that, ENS went ahead and give it the credit, and issued the credit to appellant, my client, without, okay, here you have no choice, you take it or leave it. That is the situation. That's what happened back then.
Okay, thank you very much.
Okay, have you concluded, Mr. Wang?
Yes, I have,
Okay.
Just Stanley, yeah, thank you.
Thank you. Then let me ask Judge Aldrich if he has any final questions.
I do not, thank you.
Okay, and I do not either, so this case is now submitted and the record is closed. Today's hearing in the appeal of East West Bank is concluded, so we'll go off the record now. I want to thank everyone for participating today. The judges will meet to deliberate and decide the case, and will issue a written opinion within 100 days.
Thank you, judges, and
Yeah,
Mr. Wayne.
thank you.
Take care.
Thank you. Yeah.
Thank
Mr.
you.
Wallace.
Thank you all.
Bye-bye.